The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Hello, I'm Rick. Welcome to RapidVisa Live, now streaming on YouTube and Facebook. Ask your immigration questions in the comments section during the live stream for a chance at $100 RapidVisa credit towards a future service. Stay tuned because the winner will be announced at the end of the show. Please try to make your questions thorough and in one single comment so we have enough information to address them. I'd like to introduce Isela, who's joining me today. She's going to start us off with some news. Take it away.
Hello everyone, good morning. We're starting with news about the USCIS proposing naturalization fee increases of 83% for 2020. The USCIS recently proposed fee charges in the Federal Register for all USCIS filing fees. While some of the fees are in fact decreasing slightly, such as the biometrics fee, a few fees are increasing significantly. The hardest hit are children under 14 years old applying for adjustment of status, who will see the fee increase by $370, and the naturalization filing fee, which is increasing by an unprecedented 83% to $1,170. This will be a $530 increase over the current filing fee of $640. The Federal Register is open for public comments on the proposed fee changes until December 16. The dates which the fee changes go into effect have not yet been announced, but could be anytime shortly after December 16 to early 2020. Please follow us on social media to learn as soon as the fee changes dates are public. If you're considering applying for an immigration benefit within the next few months, now is a good time to lock in the current prices and file as soon as possible. See rapidvisa.com to get started with your free account.
Thanks, Isela. We have one other public service announcement. Over the last couple of weeks, we started receiving RFEs, that's requests for evidence letters, requesting that the petitioners attend the interviews. Now, this isn't a common issue, but we did want to address it and bring it to your attention. Just because it was a surprise to the petitioners, because we normally tell people that you're not required to attend the interview. The alien beneficiary is required to attend the interview, but not always the petitioner. So this is kind of strange and kind of new. We felt that it was important to go ahead and announce this. And so far it's been with two countries that we've seen. One was Jamaica and one was Dominican Republic. Now, we surmise that it was probably due to the fact that the petitioner didn't have a good bona fide evidence showing the relationship. I mean, that's just what we're guessing at this point. But anyway, the reason why I'm sharing this is you want to make sure that you provide the bona fides, okay, evidence of your relationship, whether it's with a fiancé visa and you're showing intent to marry, or if you're filing for a spousal visa and you're showing that you have a bona fide legitimate marriage. You want to make sure that you provide plenty of evidence. And again, if you do receive a request to attend the interview, unfortunately you must attend in order to comply with the request and get approved for the visa. Again, this is not a common issue. I want to share that with everyone, let you know so you don't get alarmed, but we have recently started seeing this, so just be prepared if you do receive that request. And you can always contact us if you have any questions or concerns, and if you do receive that type of request.
And we started our questions with Melissa. She's asking, my husband had an interview July 5th. He's on an administrative processing. Is that normal? They kept his medical and passport. So if you're referring to what you are looking at on the screen when you're trying to check the status and you see administrative processing, you should wait for them to notify you, if they need any additional information. The fact that they kept the passport and the medical, are good signs. Usually they keep that when they're going to issue the visa, but If it says administrative processing, most likely they will need some additional information. It is kind of odd that they didn't inform him at the appointment of what he needs. So just be checking your email, I would say, and keep up with those notifications from them.
And just to add to that, we're starting to see administrative processing becoming the norm now. I'd say over the last 12 months or so, more and more cases are going under additional scrutiny, and consular officers are requesting more evidence. Basically, administrative processing just says that they need more time or more information to adjudicate your case or to approve a case. It's really, like I said, it's part of the normal process now. I'm actually more surprised now if you don't receive an RFE or go under administrative processing now than in years past. But just follow the instructions. They should give you a letter explaining what they're requesting, and just provide whatever they're asking for in order to comply with the request, and then you should receive your approval notice. In some cases, they may send the case back to the USCIS, but that's a different process. You can always give us a call if you've received more information, and we could probably look at your situation and provide additional information. Okay, the next question comes from, Vanessa Nelson. How long does it take for the NBC Stage to send the NBC to send a welcome letter if my I-130 was approved on October 4th? So I'll tell you, when it comes to time frames, there's just so many variables involved. It's difficult to gauge right now because everything is taking longer. Processing times are taking longer. It's taking at each and every stage. And for a spousal visa, you're looking at the USCIS stage. Right now, it's taking about 8 to 11 months. The National Visa Center is taking about 1 to 2 months processing time. But if you haven't heard from them in this amount of time, I would personally contact the National Visa Center stage, or the National Visa Center. If you don't have the contact number, you can look it up online, or you can also give us a call, and we'll get that information for you. But don't let too much time go by. But normally, you're looking at about 4 weeks or so to receive some type of notification. Usually you'll receive a letter requesting payment for the NVC processing fees. Okay, that's going to be for the affidavit of support as well as the visa application fee. So you should have received that. Then you'll also receive a detailed checklist of civil documents you'll need to provide, the affidavit of support, all the financial supporting documents. So again, contact the National Visa Center and make sure they have in fact received your paperwork, but they should have received it by now. And usually they don't send out paper mail anymore. It usually comes through an email. So you may also want to check and make sure that you have that your contact information is correct. Your email address, your home address, phone numbers, things like that. But you can confirm that with the National Visa Center, but definitely give them a call.
And we continue in YouTube with Brian Hannam, who is asking, when my K1 spouse arrives and I fill out the AOS, I need to know how to fill out the paperwork for a name change and deal with her passport from Brazil. Thanks. So yeah, if we're talking about a name change, obviously for your fiance, you'll be able to actually change her name on the application if you are referring to using her new married name. If you just want to change the last name to now your last name, since you will now be married when she arrives to the U.S. The USCIS, the only thing they need from you will be your marriage certificate proving that you got legally married, and you are allowed to change her last name to yours, even though the name will appear different on her passport, and her birth certificate obviously will have her maiden name. For them, the only thing they need to see is the marriage certificate again. So if that's what you're referring to, there's nothing that you need to do, no court documents. You will just need to fill out the application with her new name, and obviously her maiden name or previous names will be added in there as well.
Samar Pivaz on Facebook asks or states that I'm unemployed. Does it affect my U.S. spousal visa? I have never worked. Now, you don't state whether you're the alien beneficiary the one who is applying for the immigration benefit, or if you're the sponsor. I'm going to assume that you're the alien beneficiary, the one applying for the spousal visa. So to answer your question, no, it's not going to affect your case or your petition if you haven't ever worked before. Now, having said that, your U.S. citizen sponsor or a green card holder sponsor would have to prove that they meet the financial requirements and prove that they can sponsor you and show that you're not going to become a public charge and collect means-tested benefits. But that would not apply to you. So no, it doesn't matter if you've worked before or not. And on your application form, you can simply enter unemployed and enter your home address or your residence, and that's all you need.
Okay, and we continue on Facebook with J.R. Alan Estrada, who is asking, do I need to submit our pictures together when I apply for adjustment of status? I just got married last November, and I'm now applying for adjustment of status through RapidVisa. In this case, you are not required specifically to provide your pictures together. We do have a lot of customers, wanting to include for example, their marriage pictures. We can include them as extra documents, but it is not a requirement. Obviously, the only pictures that are required here will be passport-style photos for your spouse now.
Not sure of the name on there. Maybe it's just a handle or an email name.
Username.
Coens, yeah, username Coens123 on YouTube. If I'm on holiday for 3 weeks and meet a girl and get married to her within those 3 weeks without planning to do so before my holiday, what should I do? Well, this sounds more like a family planning question instead of an immigration question. But if you're asking about how to get prepared for maybe a spousal visa or something, you can always go to our website at rapidvisa.com, create an account, start answering the questions in the online questionnaire, and we provide a lot of valuable information in preparation for the immigration process. But if you're preparing, for the marriage process or something, you'd probably want to go to the U.S. Embassy website, find out what the requirements are in that particular country, because every country is different. And so I'm not sure if that addresses your question or not. You can always give us a call and provide more information, and I'd be more than happy to assist you any way I can.
Okay, and we continue with the next question from Facebook, from Crystal Medina Villarreal, who is asking, how accurate is CAC status or SEC status? We have been calling the embassy, but they say their system does not show approved yet. My status shows issued since the 9th of December. So yes, we've seen this before. I would be able to tell you that the CAC status, it's not sometimes up to date with what they see on their system. Sometimes we've seen that it says approved and they don't see it on their system, or vice versa, where they see that it's still waiting, but it's already been approved when you call them over the phone. So I would say, try to trust the agent that you're speaking to. It's great that you're actually getting someone on the line that's able to assist you, because they will go from here, from what they see on their system. And yeah, don't let it stay as it is. Just keep contacting them as much as you can.
And to add to that, the websites aren't always accurate and up to date. We've seen quite a few delays in making an update to the online status. So if you're unsure, you can always contact the USCIS, or depending which stage your case is at, contact the appropriate agency or department just to find out. But you definitely don't want to let too much time pass by. We've heard of some applicants, some customers just waiting forever and then find out their case had expired. So don't wait too long. Okay, next question comes to us from Karen. Would it be possible to get married in the U.S. on a K-1 visa and come back to the Philippines right after marriage while processing for adjustment of status? So just to let you know, the K-1 Fiancee Visa is a one entry type visa. Okay, this is not a multiple entry visa. So a K-1 Fiancee Visa is for the sole purpose of coming to the United States and getting married and filing for adjustment of status to get a green card. It is not to travel back and forth. So to answer your question, no, you should not travel until you get your green card, okay? And now if you have an emergency come up and you're unable to get your green card and file for adjustment of status, at a minimum, you need to file for what is called advanced parole. That is the travel document, okay? You do not want to leave the United States without that travel document. And here's why. If you travel back to the Philippines without that travel document, there's a good chance that the CBP agents are going to block you from re-entering the United States, and you may have to start the process all over again. We've heard this happen far too many times. Someone comes to the United States, they get married, then they get the call that a family member's sick, and then they've got to travel back before they've even applied for the green card or received the advanced parole card. So I wouldn't do it. If you have to, just be prepared to start the process all over again, more than likely.
Yeah, and I would like to add to that, especially to our customers here at Rapid Visa. When you adjust your status with us, we actually assist you to send the advanced parole application. So you're actually, applying for that as well. It is important that you inform us, if you have an emergency when you're applying for your adjustment of status, we might be able to, go with the USCIS instructions and try to request it to be expedited for this advanced parole, so you can, get this document and be able to travel and re-enter the country. Okay, and we continue now to Facebook with Natasha Hayes. If I've already started the K-1 visa process and received an RFE, can I still use the services Rapid Visa provides? So yes, that's one of the great benefits of using our services. We are not only going to assist your, the petitioner to petition their fiance. We actually stay with them throughout all the stages of the process, from the embassy process and all the way through until their fiance is here. So yeah, if you received an RFE, we obviously can assist you with that as much as we can. There might be things that we need from you, or that we need you to do, things that you might need to write, but we can definitely help you. All you have to do is just upload your RFE letter to your Dropbox and your Rapid Visa account. We'll take a look at it and we'll go from there.
Okay, now just to let you know, you must have a paid account with Rapid Visa in order to upload an RFE letter, a request for evidence. Now, in your case, Natasha, if you process this petition on your own or through someone else, and you're looking to receive assistance from Rapid Visa, more than likely you'd probably have to contact us first and send us a copy of the RFE letter. There's many different ways that you can submit this letter to us. We would need to review the RFE letter first before we could accept your case, because there are some instances or cases when you may require legal advice, and since we are not attorneys or a law firm, we cannot provide legal advice. So we'd probably want to see that RFE letter first. Now, if you're already a customer, as Isela said, just upload the letter, and of course we'll assist you with that. That's part of our service. Okay, on to Facebook. We have Wayne Trumbo asked, how long is the green card interview? It could take an hour, maybe 2 hours. It just really depends on your case. Every case is different. We've even heard where some applicants had to come back for a second interview. So it really just depends. If all your documents are in order and your case is very straightforward, there's no background issues, no, criminal history, things like that, and you have bona fide evidence of a relationship, you've been commingling finances, and everything's straightforward, the interview process shouldn't take that long. But every case is different, as we've said. I've heard it taking anywhere from an hour to 2 hours, and in some cases, some being called back for a second interview. I wish we could give you a better time frame, but that is not something that the USCIS really publishes. They do list processing times, but not interviewing times. I actually went to an interview with my spouse, and our interview probably took 15 minutes with 2 different officers, and so it wasn't very long at all. It just depends on the case.
Okay, and we continue on YouTube with Dennis R., who was asking, is it easier and faster to apply for a fiancé visa or to get married before and then apply? And what is the timeline between the two? So yeah, this is the question of the million. You know, it's something we get asked very frequently. So yeah, there's many differences, you know, talking about time. Nowadays, they are pretty backed up with both petitions. It is also the difference between the time, you know, that your fiance takes to get here to the U.S. So that's one of the benefits, you know, if she can come here, a fiance come here to the U.S. and wait here, you know, for her green card versus when you get married, they have to wait outside. There's also differences between the fees. So, you know, it's really what you're intending to do and how fast you want her to, maybe if you want her to be here as soon as possible, you know, obviously the fiancé visa, they'll get their visa and be able to travel here as soon as possible. But as Rick said, when it comes to timelines, we've seen fiancé visas being processed faster than, you know, spousal visas, and vice versa. We've seen spousal visas being processed much faster than fiancé visas. So it's really, you know, up to the officers.
One other thing to note, the timelines can also depend on the country where the alien beneficiary is coming from. Just to give you an example, from the Philippines, it can take you up to 10 days just to get a marriage license. Okay, that's just so you can get married. Then after you get married, you have to file your paperwork with the PSA. That's a Philippine Statistics Authority. That can take up to 2 to 3 months to get your certified marriage certificate back. So really it depends on the country. Every country that we work with has different requirements, different timelines, and that's before we even start talking about the USCIS process, the National Visa Center process, and the U.S. Embassy process. So it's so difficult to talk about timelines and what is easier and what's more difficult because everything really depends on your scenario and on your situation because what may be easier for me may not be easier for you. So a lot of these questions may require you to actually give us a call, explain your situation, your scenario, and then we'll go from there. And if we don't know the information, if we don't have the answers, we know where to look it up. We can go to the U.S. Embassy website. We can find out what their requirements are, how long it takes to obtain the civil documents. But I can tell you just from, you know, general practices, the fiancé visa is usually simpler, less expensive, and usually takes less time up front just because it does not include the lawful permanent resident card. It is not an immigrant visa. It does not include the green card. That's why on a fiancé visa you have to file for adjustment of status to get the green card. So there's a lot of variables involved with this when we start talking about timelines and what's easier and what's more difficult. Next is Omar and Kate on YouTube. My wife, let's see what's this. My wife's birth certificate was registered a year after she was born. Why do we need something, a birth certificate, and what's the difference? I'm not sure the onlyness birth certificate. I can tell you, if you're filing for like adjustment of status, you just basically need the birth certificate to be registered from the appropriate civil authority. So I'm not sure if that's what you're asking. They want to see the long form. Okay, the long form of a birth certificate has both parents listed on there, and then it's going to be certified. That means stamped, sealed, you know, or some type of seal from the appropriate authority. So that's really what you want. And then if it's in a foreign language, you need to have that document translated to English. And whoever translates the document to English needs to sign a certificate of translation, basically stating that they're competent in translating. So I apologize if I didn't address your question appropriately. You can always give us a call and provide more information. I'm not sure what, it could be a typo or something that says onlyness birth certificate. I'm not familiar with that term. So you may want to give us a call on that one.
Yeah, and I believe there are some countries also that, and we're also able, as Rick said, to look up the requirements for each country. Some countries I know they allow people to register their birth until later, maybe until the baby is months old or a year old, until they need to go to school, I've heard as well. And sometimes the USCIS, I believe we've seen this before, requires additional information. They see the time frame between the child was born and the child was registered with the civil authorities. So they might request, records from hospitals or other records depending on the country. So yeah, if you call us and give us a little more details, we'll be able to look up the requirements for the countries and assist you as much as we can.
That's a good point. We just received an RFE, a request for evidence letter, where there was a late birth registration. The couple had waited 9 years to register the birth, and now the consular officer is requesting a DNA test. They want to confirm the relationship. So on these late registrations, be prepared to provide additional information. As Isela said, you may need secondary evidence. The consular officer or USCIS officer may even require a DNA test. It just really depends. We're starting to see some strange and different requests here recently.
Okay, and we continue to our next question from Facebook, from Tina S. Lampo. She's asking, it is better to front load your evidence and then side load again at NBC. Sending the minimum is what makes them ask for so much at the interview. Let's see. So yeah, so if you're asking about the way you scan the documents, there is a way to scan them. They want to see just one-sided documents. That is very important. Also, not sided documents. You need to put them in the right vertical position, not horizontally. So yeah, there's a lot of things that they require, especially at the NBC system. It's very sensitive, so you want to make sure you upload clear images and legible images of all your documents.
Okay, may have skipped over one there. I'll see that from YouTube. We have Rico. Says, hi, I'm from the Philippines. May I know what is the requirements for a Fiancee Visa? Should we meet first before doing anything else? Okay, so the requirements for a Fiancee Visa is quite simple. First, you must be a U.S. citizen to petition for a foreign fiancé. 2, you must have physically met in person and be able to show that you've met in person. That's pictures of you together, your travel itinerary, plane tickets, receipts, things like that. And then you both must be able to prove that you're legally able to marry. And so that means if you were married before, you're going to need copies of your divorce decrees. In the Philippines, you're going to need a copy of your CNOMAR, that certificate of no marriage. Other countries have similar documents like that showing that you were not married before, or that you are legally divorced or the marriage was legally terminated. So you have to prove those 3 things. And then you're asking if you should meet first. Well, you can go ahead and start preparing for your trip and preparing for the meeting. And that could include creating an account on our website, answering the questions in our online questionnaire, having access to our knowledge base and information, and just start preparing. And then you'll also want to start doing some research on the country that you're going to visit, because every country has different requirements. So there's a lot of things you can start doing in advance and preparing for your trip. But as far as the immigration process goes, you really cannot submit your petition until you meet all the requirements, and showing you've met in person and that you're legally able to marry. And then there's also some more requirements down the road, like meeting the financial requirements, things like that. But that's in the later stages.
Okay, and we continue with this question from Faye. She's asking, does a K2 child attend an embassy interview? So yes, all visa applicants must attend the interview, including children. Not necessarily, obviously, might not ask them questions directly, but they want to verify the person that they're issuing a visa to. We were also discussing here with Rick that it's common when a child attends an interview with their mother. Obviously, they're not going to let a minor go by themselves. They have to be accompanied by an adult, a legal parent or guardian. So they put them in a separate room, just have them, they're comfortable and be able to ask and identify certain questions they might want to address.
Okay, on YouTube, Susie Liz asks or states that the pendulum regarding the ease of immigrating a loved one has swung so far to the side, being increasingly difficult. Is it all likely that I will swing back to being easier or faster? That's a tough question. With the current administration, and it looks like they're really scrutinizing legal immigration more so than we've probably seen with previous administrations and in previous years. This is just my opinion, but based on everything I've seen over the last couple of years, I would only expect it to get more difficult and the process to be more cumbersome, to take longer. It's just the way it's been going. It seems like every month there's a new obstacle, some new requirements, and a lot of these are coming through executive orders. They're not coming, through the House or the Senate. And so we just don't know. I don't see how it's going to get better if this is their approach and their take on immigration to make legal immigration more difficult. So I can only expect, at a minimum, it's going to stay where it's at, but I don't personally see it getting any better, unfortunately.
Okay, we continue with a question from Facebook from Tina S. Lampo. She's asking, is there a cap on how many CR1s or IR1s visas can be given out in a year? Could this be why people who were DQ'd in September have not received an interview date yet? So they do kind of have a control of the amount of petitions that they process a year. There's no really a certain amount that they have, but they do have the certain amount of applications that they can have on an office. So the processing times have gone up so much. I can tell you that in September, if your application was received in September, it is too early to receive an interview date. By now you should have the receipt notice. You should have received this email or text message and the letter from the USCIS telling you that they received your application, but not even an approval notice should be received yet, because the minimum we've seen for this applications is 5 months, but it's going up to 20 months. So depending obviously on your situation, if you're a U.S. citizen, a permanent resident. But yeah, you should be patient. That's all we can tell you, and just wait for this interview.
Okay, next question comes on Facebook from Shantae Campbell. After you pass the K-1 visa interview, can you request the visa to come quicker than 7 to 10 days? You can request it, you can ask, but it's been our experience that it takes at least that long, because here's what happens. They're going to send your passport off, to basically a printer where they actually physically print the visa into your passport. So it takes about 2 days to get over there, a couple of days to print the actual visa. Then they have to send it back and they deliver it through a courier service. So actually 7 to 10 days, that's pretty quick considering the process. I have heard of some people receiving it in as little as 4 or 5 days. But actually when my wife received her visa, it actually took a little longer than 7 to 10 days. I believe it was about 11 or 12 days. And I remember holding off to purchase the airline tickets to come back to the States just because we were waiting for the visa. And those days do not count the weekends. So usually when they tell you 7 to 10 days, that's 7 to 10 business days. So 10 days would actually be 2 weeks. Here I was counting on the 7 to 10 days, not actual business days. So you can request, but I would not expect them to move quicker just because it's a lengthy process.
Okay, we now have a question from Nauman Sashad from YouTube. For Fiancee Visa, do we need to show our online nikah, means Muslim wedding, nikah paper? So for Fiancee Visa, once you are in the U.S., obviously you are going to get married here in the U.S. They don't necessarily need to see your religious documents as far as your marriage. So if you decide to get married through your religion, they don't necessarily want to see those. They do want to see your legal documents. So depending the county and the state where you got married, you might have a marriage certificate, you might have a shorter version of your marriage certificate, and then you might have your marriage license. But what they necessarily need to see is your marriage certificate.
Okay, Tina Lampo asked, why is it that K-1 petitioners get to pick their own interview date? It should be this way for spousal visas also. I'm not familiar with being able to pick out any interview dates, not for a fiancé visa or spousal visa. Here's how for everyone out there, here's how the process works for a fiancé visa and spousal visa. First, you've got to get approved through the USCIS stage, okay? Then they're going to send your documents on to the National Visa Center stage and the National Visa Center. The National Visa Center is going to reach out to the embassy and find an available interview date, and they'll send it out. Now, maybe you're referring to being able to change dates on a K-1 fiancé visa. In some cases, you can look on a calendar online and maybe pick a different date or change a date. And then again, maybe you're referring to maybe like a tourist visa or something like that. But it's my understanding with what I've seen in the process is that the National Visa Center will reach out to get an available interview date, and then they'll send that out to the actual applicant. But I have heard of cases where you can change those dates by contacting the U.S. Embassy, and that also applies to a spousal visa as well. If that particular interview date is too soon and doesn't work for you, in some cases you can actually extend it out, but I believe you have to physically contact the U.S. Embassy in order to change those dates.
Yeah, and I want to add to that. I know there is some countries where for spousal visas, they want you to choose your date. So they do make you go on a website and choose the date of your interview. So it also depends on the country from where you're being petitioned. And now we continue with a question from Juan, who's asking, can my spouse attend the biometrics appointment with me? So biometrics appointment are usually scheduled at your USCIS local office or the closest support center to your area. So at the appointment, they're obviously going to take fingerprints, they're going to take photographs and signatures for some applicants. So you might go with the beneficiary to the appointment, but sometimes they might not let you in. They might leave you at the waiting area. It all depends on the room that they have at the office. Some rural areas might have smaller offices than the big cities. So you can contact your local office. They usually have their contact information in the appointment notice at the bottom. You can find the address, and you usually find the local phone number for them as well.
Okay, Ash McCook asked, during the AOS process, how long roughly is a work permit granted? So right now, you're probably looking at about 3 to 4 months after you've submitted your actual application for adjustment of status to get the work permit. Although, take that with a grain of salt, because everything when it comes to dates now is taking longer than it has in the past. So again, these are just rough estimates, 3 to 4 months. How the process normally works is that you submit your paperwork, and then you're going to receive your receipt notice hopefully a couple weeks after you've submitted the paperwork. And then shortly after that, probably 2-3 weeks later, you're going to get an appointment letter for your biometrics. That's to go in and take fingerprints and photographs. And then usually within 4 to 6 weeks after that is usually when the combo card comes. That's your advanced parole card and your travel permit. It all comes on a little card that looks like a driver's license. And then hopefully after that, about a month or two later, you get your actual interview. And then if everything goes well, in 2 to 3, 4 months after that, you should receive your actual green card. So right now, the entire process is taking about 10 to 12 months. And that combo card usually comes somewhere in the middle of that process right now. And that's what we're seeing. You can go online and maybe see what the current processing times are for your local centers. But this is just information we're receiving back from our customers. And it's just taking much longer than it has in years past.
Okay, and we continue on YouTube with Michael and Haiti. she and him is asking, with the increased spousal visa times, will K3 visas be issued again? So yeah, for K3 visas were issued to spouses waiting outside of their countries to be able to travel to the U.S. and wait here during this petition process for spouses. This was something that was given a few years back in the Obama days, I believe. So now with this current administration, we've seen a pause on this K3 visas. We don't know if this will happen again with the time frames that they have. I believe this is more of a legal question as well. If you want to go to an attorney and see if you can request this visa, or if you will be able to qualify. We unfortunately don't assist with K3 visas, but you can consult an attorney for that.
And one thing to keep in mind about a K3 visa, even if they do accept it at the NBC stage, it does not include the green card. So personally, if I were applying for a spousal visa, I would not want them to switch it over to a K3, regardless of the time frame, because when you factor in the time for adjustment of status and all the additional fees, filing fees and everything, it's just going to take even longer and be a lot more expensive. But we haven't heard anything from U.S. Department of State or any of the agencies regarding bringing back K3s. As far as I know, the K3 is still available. It's still listed on the USCIS website. It's just that I haven't heard or seen one actually adjudicated in probably 5 or 6 years. And if you go on the USCIS visa statistics page, they actually produce statistics every year. I did see where there were actually 6 K3s processed in 2018. I don't have the numbers for this year, as they're not released usually until February or March. But there were 6 that were actually processed. And it's up to the NVC, the National Visa Center, to decide whether they process or adjudicate the I-130 and the I-129 together, because it requires both forms. Obviously, the I-130 is for the spousal visa, and the I-129F is for the K visa. But if you want to try it, as Isela said, we used to offer the K3, but once they stopped accepting them at the National Visa Center stage, then we kind of did away with them. But if you wanted to process it, you could still go that route. We could probably even still assist you with it if you wanted to contact us. But as it stands right now, the processing times aren't great enough to warrant the K3. It just doesn't, in my opinion, it just doesn't make it worth it. Okay, the next question comes to us from Stefan Fagan. Hi, my case was forwarded to the Department of State. I'd like to know what is next. So this really depends on the visa type. So if it's a fiancé visa, you go to the National Visa Center stage, and really the only thing the NVC does is assign a case number, and then they'll forward it on to the embassy. However, if you're applying for a spousal visa, there's quite a bit more to do. Okay, they're going to send out a letter requesting that you pay the fees for the affidavit of support and the DS-260, which is the visa application. Then they're going to start collecting documents, civil documents like birth certificates, marriage certificates, and any other documents that may be unique to the particular country that you're coming from. But again, it depends on where you're at. Now, if it's a fiancé visa, like I said, they're just going to sign a case number. They're going to reach out to the embassy, get an interview date, and then they're going to forward your packet on, and they'll give you instructions on what to do next. But if it's for a spousal visa, there's quite a bit of more work to do.
And we have a question now from YouTube from the username Extraordinary Mitch. He's asking, hi, would it cause a problem if I was deported due to a failed asylum case in 2008 for a K1 visa? So it will be, a tough answer or tough question to answer because we don't know exactly why you were deported. Obviously, for a K1 visa, an officer will determine the reasons why you were deported and see how they decide, or if they want to question you more, they will obviously request additional evidence. This might be in the records and they'll be able to see the reasons why. If it was just the fact that they failed to give you asylum in the country, I mean, it's something, again, that they will consider and either question you by requesting additional information or by questioning you at the time of your interview.
Yeah, for something like this, you'd probably want to consult with an immigration attorney. Again, Rapid Visa, we're not attorneys, we're not a law firm, we can't offer legal advice. But anytime somebody has legal issues or legal concerns, requires legal advice, we highly recommend that they contact an attorney. You can go online, probably find one in your local area, or a national attorney, just wherever you're at. If you're in a foreign country, you may want to actually contact someone who has experience with the immigration laws in the United States. But I would definitely search online and find one and consult with them.
Yeah, we usually recommend you to contact an attorney before starting, your case, because sometimes if a case is denied, you will just be wasting money and time. If you might be able to do something different, so you want to save time and money.
Okay, Ernest Mackey asked, hello, my fiance and I have decided to get married in the Philippines. Now I have applied for a Fiancee Visa. So how much paperwork is involved, and are we starting over? Let's see, you decided to get married. So if you filed for a Fiancee Visa and you got married, you are no longer eligible for a Fiancee Visa. So that would require you to start over. Because as soon as they find out you're married, you would not be eligible for the Fiancee Visa, and that would be denied. Now, if you have an active case with the USCIS, you're going to have to submit a letter and request that they cancel that. You don't want to have more than 2 active applications in the system because it could appear or may appear like immigration fraud, and that's the last thing you want with immigration. You don't want to appear fraudulent. But again, you may also want to give us a call too and share your scenario and your information with us just to make sure that we have all the details here. But anyway, if you married and you filed for a spousal visa, you're starting all over. That's it.
Okay, we continue on Facebook from Muhammad, who's asking, my fiance and I met on Facebook 2.5 years ago. Do we need chat history from both parties, or just alien can take this to the interview? So yeah, if you're applying for a fiance visa, you do need to prove that you have physically met within the past 2 years. Chat history is usually not very recommended. I mean, you can include it and we can add it as extra documentation in your file. But I mean, it does need to be within 2 years. 2.5 years will be over 2 years. So anything within those 2 years prior to the date where you're applying, that'll help you. But typically we suggest that you include pictures, plane tickets, any receipts that you have from when you visited your fiance in her country or wherever you met, stamps from your passport. All those things will be considered highly over chat history.
Okay, Derek on YouTube asks, can you pay for the adjustment of status with a credit card? If you're referring to paying Rapid Visa, yes, you can pay our fee, you can pay the filing fees with a credit card, debit card, anything like that. Now, if you're talking about paying the USCIS filing fees, there are many of the forms out there, like the I-45 and several others that you can pay using a credit card. There's a special form that you have to fill out and enter your information, credit card information, and you can submit that along with your adjustment of status petition or application. So it really depends on the forms and the process. So if you're doing this on your own, you can find the form online. And if you're doing it with us, of course, you can pay us with a credit card, and we can write the check for the USCIS filing fee for you if you want to add that on a credit card.
Okay, we continue on YouTube with a question from Sherry786, who is asking, how long does it take for NBC to review the resubmitted documents? So if we're talking about, you submitted documents and now they rejected a document or they're requesting new documents and you submit new documents, it's usually the same amount of time as it took them to review them the first time, which could be anywhere between 3 to 6 weeks. We've seen this, go up to 6 weeks. So we suggest that you submit them correctly the first time, and we try as much as we can to submit them properly when you send us documents. But if they require new documentation, it could be, again, 3 to 6 weeks.
And with the NBC Stage now, most documents are being submitted electronically. So if you received an RFE letter, usually the instructions will tell you exactly how to resubmit that. And a lot of times your case has already been reviewed and they're just waiting on that one document. So in some cases, it doesn't take as long as the initial process. Usually, if it's just missing that one item, one document, sometimes it can usually only take about a week or two, again, depending on the documents they're requesting. Okay, Roxy Wells asks, why does the CR1 take longer for a green card sponsor? The immigration, okay. This is actually a good question, quite simply, because it's very involved as well. The immigration, USCIS and the other agencies only give out a certain number of visas for green card petitioners. Okay, for a spousal visa, if you're an F2A type preference, you're looking at right around 114,000 visas a year. That's all that's available. Now, just to let everyone else out there know, if you're a U.S. citizen petitioning for a spouse, it's unlimited. Okay, so there's no delays on getting this process. But this person is asking if they are a green card holder petitioning for their spouse, why is it taking longer? And it's because there's a limited number of visas, and they have to go through a process, and they have to apply for a priority date. Okay, that process takes a long time, and then the priority dates are preferences based on the country they're coming from, okay, the number of visas that are available, and it comes down to you're actually going in line, and there's a link and a website available for priority dates and processing times, and you can go research those, find those, or you can give us a call and we'll point you in the right direction. But unfortunately, that's why it takes longer. It's not unlimited, and it's a long process. Right now, I think it's taking anywhere from 2 to 3 years, whereas a regular spousal visa is taking about 8 to 12 months. So this is taking a couple months longer. And that's for the F2A category, okay? That's for a green card holder petitioning for their spouse. Now, if you're petitioning for siblings or other relatives, that preference goes down even further. You can go into 3 or 4, but for the spouse, right now, it's called the F2A preference. And right now it's taking, like I said, anywhere from 2 to 3 years. And I wish I had better information for you. If you really want to speed this thing up, if you're close to getting your citizenship, it's highly recommended that you do that before you file the petition. Now, if not, if you get your citizenship later on, you can go in and update your status on this, because that's very important to know. For those that if you're just waiting on the timeline, to be eligible for your citizenship, say you've already been in the United States and been a green card holder for 3 years and you only have to go 2 more years, as soon as you get that citizenship, you'll want to update your status, and that could really expedite the process, and you wouldn't have to wait on that priority date.
And now we continue on YouTube with Extraordinary Mitch again, has one more question, and he's asking, if my sponsor doesn't meet the income requirements, can we use my assets and fiances in replace? So yes, assets can be used to try to meet the criteria of your current income or show stability for prior years of your income. However, you need to have in mind that for assets, the USCIS will only consider 1/3 for your assets as the sponsor. If you do use your fiances, they will consider only 1/8. I believe it's 1/8, correct?
1/5.
Or 1/5. I'm sorry. Yes, of the assets. So if we consider this, the amounts of your assets or the total values need to be really high for them to make a difference and help you with your income.
One other thing to note on that, income is very subjective, meaning that comes down to the discretion of the officer reviewing your case. We've seen numerous cases where the USCIS officer didn't even accept the assets being included, or if they didn't accept them, they didn't believe that they were adequate. Keep in mind, when you're using assets, you need to first prove ownership, okay, and that's usually by providing maybe the deed of your property, the mortgage statement on your house. I mean, anything showing that you physically own the property. And then secondly, you have to show the value of that, and it needs to be appraised by a third party, somebody who is actually in the business of appraising assets. And then the third and last thing is it needs to be able to be liquidated, sold, converted to cash. So they look at those three things. A lot of times, people will provide the title to their car. Well, you cannot use your primary vehicle as an asset. It has to be a second or third vehicle. And I actually bring up vehicles, and they're not really a good example of an asset because it's very rare that the officer even accepts that as an asset. But again, keep in mind that income's very subjective, and they don't always accept assets. If you do use assets, it's best to have cash, stocks, things like that. And then it's best if the cash and stocks are in the United States. Sometimes foreign assets cannot be taken by the U.S. government, cannot be liquidated. Again, this gets very complicated. It's really best to obtain a joint sponsor. If you're unable to meet the income requirements, you may want to obtain a joint sponsor, a qualified joint sponsor that can sign an affidavit of support and then can show 3 years of sustainable income. Sustainable income is income that is over the required amount for that 3-year period of time. You don't want to have, earn $50,000 one year, zero the next year, and then $60,000 the next. It needs to be consistent and sustainable. Otherwise, expect to receive a request for evidence. Okay, the next question comes from James. I can't leave the country to meet my fiance. Should I have her come to America on a tourist visa so we can meet first? We want to get a K-1 visa. That's a tough question. You can apply for a tourist visa, but I'm going to be honest with you. Denial rates are extremely high for tourist visas. The reason being is that most applicants have a very difficult time showing or proving that they have strong ties to their country and that they're not going to come to the United States and stay. And since you've already told us you're applying for a K-1, now we know your intent is to have them stay here in the United States eventually. Look, you can try it. The fee is not very expensive. It takes 30 days to get an appointment. But also keep in mind that later on down the road, when you do finally meet and then start applying for the K-1 Fiancee Visa, that tourist visa is going to be out there, and they're going to see, oh, you applied for that. Now you're applying for a Fiancee Visa. And if that doesn't work out, you apply for another visa, and it's going to start looking like possibly immigration fraud. So please take that into consideration. Keep that in mind. But you may also think about maybe meeting in a neutral country. I don't know where your fiance is from, but there's numerous countries that folks can travel to without a visa, and that you may be able to travel to. I mean, it said you can't leave the United States, so maybe that's out as well. So that's a difficult situation. So maybe that's your only option is the tourist visa. But I'm just forewarning you that we see many of those get denied just because they can't prove they have strong ties. Strong ties to a country would be a good job, a family, children, things that are going to force them to go back to their home country. That's what they're going to want to see. The consular officer is also going to want to see that they have the means to travel, and not only travel to the United States, but get back to the United States.
Okay. So that was all for today.
So that'll be our last question for this session. So thanks for joining us today. And be sure to like us and comment and subscribe to our YouTube channel to get alerted whenever we post new videos. Okay, check out our channel to see if you have questions that have already been answered. And then next, I would like to announce our winner today, and it is Tina Lempo. Congratulations on your $100 RapidVisa credit. Please claim it by sending us a private message. Thanks again, everyone, and we'll see you next time.
Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. RapidVisa is a document preparation firm licensed and bonded in